commentary in this program may contain frank talk of a sexual nature. Viewer discretion is advised.
Like a bottle of well-aged Jesus juice, this case is almost ready to be served up to the jury. But will the prosecutors or Team Jackson be popping the champagne in celebration? You know, the stage is set for a real cliffhanger. You might even call it a thriller. Okay, I couldn't help that. Hello, I'm James Curtis. Welcome to E's coverage of the Michael Jackson trial. With Judgment Day fast approaching, the pop star walked in the Santa Maria courthouse to face the music. Inside, Judge Rodney Melville laid down the ground rules for deliberations and instructed the jurors on the law that applies to this case. But before closing arguments began, prosecutors scored a bit of a minor victory. Now, jurors have the option, when they're deliberating on the charges connected to serving alcohol to a minor. We'll go into that in a lot more detail. It is quite interesting. Here's what Judge Melville told the jurors according to the courtroom transcripts.
You will be provided with guilty and not guilty verdict forms for the crime charged in counts 7, 8, 9, and 10, and the lesser crime thereto. The crime of furnishing an alcoholic beverage to a person under 21 years is a lesser crime to that of administering an intoxicating agent to assist in the commission of a felony. Every person who unlawfully sells, furnishes, gives, or causes to be sold, furnished or given away any alcoholic beverage to any person under the age of 21 is guilty of a violation of Business and Professionals Code, Section 25658, Subdivision A misdemeanor. In order to prove this crime, each of the following elements must be proved. 1, defendant Michael Jackson furnished, gave, or caused to be furnished or given away any alcoholic beverage to Gavin, and 2, Gavin was under the age of 21 years.
Okay, Ricky Kleeman, play law school professor for me, which you actually do play in real life from time to time. Explain what just happened here and the significance of this instruction.
What happens is this is what we call a lesser included offense. You have, I'm going to use just the vernacular, what you have is what we would think of as contributing to the delinquency of a minor, that is serving a minor an alcoholic beverage. Well, what the case is serving a minor an alcoholic beverage with the intent to molest him. So they've just taken the lesser, the included offense, and charged the jury as a misdemeanor. Now, I know it's said that this is a prosecution victory. I think this is a defense victory because it gives the jurors the ability to convict Michael Jackson of something really minor, no pun intended, and not convict him of the rest.
And if the jurors were paying attention and remember that this was not charged initially, that telegraphs to them that this case has really come down in significance from when it was first told to them in opening what the charges were. This is a new charge. They're now hearing about a misdemeanor. I think that telegraphs to them this isn't as serious as it was cracked up to be initially.
I think the instruction is wrong. I think that the misdemeanor instruction doesn't apply here. He either gave these kids alcohol to commit some felony offense such as molestation, or he didn't, and that's the question the jurors should have asked. Should be asked. This section, in my opinion, should only apply to businesses. Shouldn't apply to private individuals in their home. So I've always taken that position.
You would have objected as a defense lawyer. You would have never wanted it in there, rather than saying, okay, members of the jury, convict him of this misdemeanor.
Because it gives the jurors an opportunity to convict him of a misdemeanor because they don't like his lifestyle, and I don't like giving them that opportunity.
I think Michael Jackson would accept that misdemeanor charge.
This is very, very highly charged discussion because this is big. It may seem like a small thing, folks, but this could be huge. We'll continue. But for now, let's take a look at the testimony surrounding the charge of serving alcohol to a minor for the purposes of seduction, folks. Not this, just the plain old, as Ricky Kleeman just stated, contributing to the delinquency by supplying alcohol just to supply the alcohol. What did Jackson serve the young accuser on that infamous flight back from Miami? Coffee, tea, Jesus juice.
During the course of the flight from Miami, did you ever drink any alcohol?
Yes.
Now, who provided that alcohol to you?
Michael.
And can you tell us then what it was provided to you in?
I think it was another Coke can or Diet Coke can.
And what kind of alcohol was it?
I think it was white wine again.
And where, did you see where Mr. Jackson got the can from?
From the little place where they keep all the sodas in the plane.
Now, where were you when you physically drank out of the container, the can?
I was next to Michael.
And did Mr. Jackson say anything to you when he gave you the can?
Yeah. He told me it was more Jesus juice, and he said that on the plane that he told me about how he used to get scared about planes, and he said that if I was scared and to drink the Jesus juice because it will relax me.
How much do you think you drank while you were on the plane?
I think I drank the whole can.
Was the can ever refilled?
Yes.
Do you know how many times?
No.
Were you always drinking out of the same can as Mr. Jackson?
Yes.
All right, flight attendant Cynthia Bell, you remember her. She tells a different story. Are we dealing with Chardonnay, Cabernet, or just plain old hearsay?
Now, how many times do you think you've flown with Michael Jackson?
I believe 3, no more than 6.
And in none of the flights that you shared with Michael Jackson, let me rephrase that. At no time on any flight you've been on with Michael Jackson have you ever seen him share wine with any child, correct?
That is correct.
You've never seen Michael Jackson share a Diet Coke can with wine with any child, correct?
That is correct.
You never saw the children drinking from a Diet Coke can with alcohol at any time, right?
That is correct.
You never saw those children drinking from a Diet Coke can with wine, correct?
That is correct.
Objection asked and answered.
Overruled. The answer is in. Next question.
All right, we all recall this testimony. It seemed to be quite compelling at the time. Sean Chapman-Holly, I want to let you finish your thought. But in addition to that, is this so-called victory, in your opinion, for the defense, showing that this case is deteriorating so much so you got to throw in a misdemeanor just to make sure you get something?
Right.
Is that something you would have wanted as a defense attorney in this case?
I'm not sure. You know, it's always a matter of strategy. The defense has to decide whether or not it's kind of all or nothing. If they feel the prosecution hasn't proved its case, then you're going for a straight acquittal versus convicting on something small. I disagree with Howard, though, that it's either alcohol for molestation or no alcohol at all, because this testimony could suggest Michael Jackson is nervous about flying. We've seen him be childlike with kids in the past, and so he's saying, here, have a little alcohol. It lowers your nerves, but it's not necessarily for the purpose of molestation.
But I don't think it's a crime. That's the point I'm making. The code section is within the business and professions code section. That regulates businesses. It doesn't regulate individuals on flights. It doesn't regulate individuals in their home. It's stuck in here to give the jury an option. And if they dislike Michael and don't think that the core charge was proved, they could come back with a misdemeanor just because. I don't like that.
Wouldn't you love, if you're Michael Jackson, to just walk out of there with a misdemeanor?
Well, I don't know. Let's talk about that when we return, because if they just have something to convict him on, what kind of message does that send for an individual who makes his life essentially based on what reputation he may have left? When we return, potato wine, stolen wine, and Judge Melville's time to define. Oh boy, I'm on a roll today, aren't I? Stay with us.
The reenactments and commentary in this program may contain frank talk of a sexual nature. Viewer discretion is advised.
Welcome back. Could Michael Jackson do time for serving Jesus juice to his young accuser? Now, there's more to this charge than just what happened on that flight from Miami that we've heard so much about. Did Michael Jackson play bartender, essentially, to Gavin at Neverland? Here's what the young accuser told the jurors according to the courtroom transcripts.
Now, do you remember, you told us that some of the times that you drank vodka with Mr. Jackson, correct?
Yes.
Do you ever remember a situation, what effect did the vodka have on you?
Well, there was just one time, well, vodka really tasted...
You're going to have to lean into that and talk so we can hear you.
I don't really understand what you're...
What effect did the vodka have on you?
What did it make me feel like?
Yeah.
Well, there was one time where the first time that Michael introduced me to vodka, he had like a glass about that big.
Objection. Calls for a narrative, non-responsive.
It's non-responsive.
All right. Did Mr. Jackson provide vodka to you?
Yes.
And how did he, and what did he provide it to you in?
In a glass about that big.
So you're indicating maybe 2 or 3 inches?
I guess. I don't know.
And what kind of a glass? Where were you when he provided it to you?
I was in the wine cellar.
And did you see him pour the vodka into it?
No.
Did you know what it was when you first sipped it?
No.
How was it that you ended up drinking that particular glass?
I walked down there because I asked where Michael was. Well, we were in the arcade, and that's what we usually kind of did. And then so I went down to the wine cellar, and I saw Michael there, and then Michael had the glass poured, and then I asked him what that was, and he said, drink it. And then he said, like...
Objection.
All right.
Non-responsive.
What did he say to you?
He told me to drink...
Just a moment. There's an objection pending, or just a narrative?
Narrative, Your Honor.
Go ahead with your next question.
What did he say to you?
He told me to drink the vodka.
And did you do that?
Yes, but I didn't know it was vodka. I thought it was water because it's, like, clear.
Okay.
So I drank it really fast, like if it was water, and then I didn't really... When I brought it to my nose, it smelled like rubbing alcohol, and then I chucked it back really quick, and it started burning. Well, I, like, took down the whole thing, but it really burned, and then, like, 2 or 3 seconds later, my head started... Like, it looked like the room was spinning, so I put my head inside the couch. You know the green couch that I was talking about? I put my head inside it so I couldn't see the room spinning, because it was kind of hurting.
I don't buy it. And we'll talk about that some more in just a moment. On cross-examination, does it sound like defense attorney Tom Mesereau might be just laying the groundwork to later contradict this witness's story?
You've told the sheriffs that Michael Jackson would give you and your brother Bacardi, right?
That was one of the things he gave us, yes.
That was rum, right?
Yes.
And you also said he'd give you Sky vodka, right?
Yes.
Jim Beam, which was bourbon, right?
I don't know what it is, but yes.
And red and white wine, right?
Yes.
Did you drink all this stuff at once?
No. It was over the whole period of time that we were over there.
Okay, but never once did you taste any of this stuff when Michael wasn't there?
No.
Okay, never took any alcohol out of the refrigerator in the kitchen, right?
No.
Never got caught taking alcohol out of the refrigerator in the kitchen, right?
I never took any alcohol out of the refrigerator in the kitchen.
To your knowledge, was your brother ever caught taking alcohol out of the refrigerator in the kitchen?
I was always with him during the day, so no, he didn't.
Would you agree that every time you were interviewed, your stories of drinking got worse and worse, correct?
No.
You initially told them you didn't drink a lot?
That's true.
Then you started telling them you drank a lot, and then you started telling them we drank every night, correct?
Well, a lot would be every night, so it would really...
Pardon me?
A lot would be every night.
And you're saying after Miami that you basically were drinking every single evening at Neverland, correct?
No, I told him that every single evening that Michael was there in those transcripts, probably when I still... I don't know.
Isn't it true that every time you were interviewed, your stories of drinking got bigger and bigger and bigger?
No.
Are you saying your stories to the sheriffs were always consistent when it came to drinking?
I'm pretty sure they are. I mean, it doesn't really matter whether I said that or not. I'm saying the fact is that we drank every night that Michael was there.
All right, now we get to the testimony that Team Jackson uses to refute Gavin's story of drinking only when the king of pop, Michael Jackson, was present. One of Michael Jackson's young cousins describes the Cabernet caper, but first, the beverage of choice for the accuser's brother, according to a former Neverland employee.
Okay, tell us about that occasion when one of the boys asked you to prepare an alcohol drink.
He was at the bar in the kitchen.
Do you remember which one it was, Star or Gavin?
It was Star.
All right. And what did Star say to you?
He asked me to make him a milkshake.
All right.
And I made it for him, and he pointed at the cabinets full of liquor, and he pointed out one of the bottles and asked me to pour some in the milkshake.
Okay, what was in the bottle?
Liquor.
Okay, do you remember which kind?
It was a Mexican kind. It was called Jimador.
He was asking you to put that in the milkshake?
Yes.
All right, did you do that?
Yes.
You put the alcohol in the milkshake?
Yes.
Okay, before you put it in the milkshake, did Star say anything to you?
Yes.
What did he say?
He told me if I didn't do it, he would tell Michael and I would get fired.
So then you put the alcohol in the milkshake?
Yes.
Okay. What did you see Gavin and Starr do in the kitchen at 1 o'clock in the morning during March of 2003?
I saw them take wine.
And when you say you saw them take wine, did you see one of them take it or both?
Both of them. They each had a bottle.
And were they in the kitchen with the bottles?
Yes.
Did you see them actually take the bottle from some location?
No, I didn't.
Okay. Did you walk into the kitchen and see them with these 2 bottles?
They didn't. They didn't see me. I was sitting to the side. They didn't see me when they came in.
All right, Ricky Kleeman, I must return to the challenge that I put out, essentially, to the initial basic testimony about the drinking. It just doesn't seem right. Doesn't have that ring of truth, to use a phrase that Howard is fond of using. I thought it was water, but then I smelled it, indicating I knew it wasn't water, and then I drank it anyway.
I drank it, I got dizzy, I put my head down, the room was spinning around. This is exactly the kind of testimony that the prosecution can argue, and argue with vigor, that this is a child telling the truth about an alcohol experience when he was inexperienced.
Howard, come on, help me out.
I don't think I can help you out. I think, in my opinion, that was one of the more credible parts of the testimony. What I thought was not credible was the bourbon, the rum, you know, the vodka and the wine.
Well, wait for the search warrant, though, because when they argue about what was in that search warrant, what they found, and all these open bottles in Michael's room that really spanned a lot of different things.
Well, that's where the testimony came from.
All right, well, let's leave it right there. We've got to get back into some more of this testimony. What is the world coming to when I can't get help from Howard Weitzman to prove a defense point? We move on now to the drinking accusation, from the drinking accusation to the prosecution's big moment in their rebuttal case, the 2003 police interview, the taped interview of the young accuser. Now, before deliberations begin, Judge Melville wanted to remind jurors about how they are to consider this potentially devastating piece of evidence.
The July 2003 interview of Gavin was offered to rebut the claim that Gavin's responses had been coached or scripted. The interview video was offered for the purpose of evaluating Gavin's demeanor and assessing whether his responses were coached or scripted. None of the statements made in the interview video by Gavin or the interviewers may be considered for their truth.
What in the heck does that mean?
This seems almost like a physical impossibility to consider the demeanor but disregard the testimony. That doesn't make any sense. And I wonder then if the defense can argue that the testimony in the video is inconsistent with the testimony in the trial. I suppose you can't make that argument if you can't consider the testimony.
I would suppose, Howard, I think that's got to be right. How can they argue the content if they're only supposed to consider the demeanor? He looked sad, he looked down, he looked dejected, or were the other descriptions?
Here's the most interesting thing to me, again, about this judge. Pre-instruction is a great idea, I think. I like when juries get pre-instruction. This instruction, however, is intellectually impossible. And Ricky Kleeman made a suggestion yesterday that I think was great. If they're going to play this video, they should have turned the sound off and let the jurors just observe the demeanor, which was supposed to be the purpose. I think it's very disingenuous to say, watch the video, but don't listen to the words, because they're not to be considered for the truth of the matter asserted. You can't unring the bell.
That is going to be the big issue, and we're going to talk about some more of these key instructions when we return. And when we do return, how does Judge Melville define the molestation charges for the jurors? Stay with us.